This court observed that the Supreme Court has not decided whether a former president may prevent disclosure of privileged records from his tenure in office, despite a determination by the incumbent president to waive the privilege. Now, I discussed this when I talked about executive privilege before, when discussing Trump v. Thompson, and I pointed out specifically over and over again this part that Judge Kavanaugh talked about as being the only issue that the Supreme Court would address, but it did not address, and it says this explicitly in the ruling, that Donald did not raise the issue of the executive privilege of a former POTUS. And I specifically said, and I've said it several times since, most recently on Twitter, on a Twitter reply to Asha Rangappa, that it doesn't matter the verity of the claim of executive privilege that he's raising. He's going to bring this up over and over again. And I don't know whether Justice Kavanaugh did this intentionally by pointing that out explicitly, that Donald didn't raise this issue and therefore we're not going to bring it up. But this is an issue that the Supreme Court would bring up because Judge Kavanaugh wanted to leave that plant in there for Donald to pick that up later, just for specifically this purpose of raising this bogus issue. But I don't know whether he did that intentionally or not, but I'll tell you this much, it doesn't work in Donald's favor in this case because Donald has raised this executive privilege issue of a former POTUS in a contention against the executive branch itself. When in Trump v. Thompson, it was against Congress, which is a different branch of government. So the executive privilege claim is stronger. And even if in this case, there is executive privilege over certain materials that the former POTUS has, like letters to people and foreign leaders that are not within the purview of this investigation or any criminal investigation, that ongoing investigation into Donald Trump, those privileges may exist. But this particular motion for a partial stay is for the classified records only. It doesn't go into anything else. Even the non-classified documents recovered on August 8th. So it's critical to remember how precise and narrow DOJ has been in asking for this stay and how impossible it is made for Judge Cannon to deny it. This court observed that the Supreme Court has not okay, told you that. Now, but as this court acknowledged, Thompson involved a claim of executive privilege by plaintiff as to records sought by a congressional committee. That is, he sought to prevent dissemination of purportedly executive materials outside the executive branch. Neither the Supreme Court's opinion denying plaintiff's request for a stay in Thompson nor Justice Kavanaugh's concurring statement suggested that a former president can successfully assert executive privilege to prevent the executive branch itself from reviewing and using its own records. So, I mean, yeah, it's self-explanatory. DOJ runs down this idea of executive privilege over a former POTUS's executive privilege, over the executive branch's assertion of executive privilege, over classified documents, over which the executive branch, by way of the DOJ and the ODNI and other branches of the intelligence community, has exclusive jurisdiction